Hi everyone, and welcome to today's seminars. And apologies that we're so long overdue in getting restarted on our seminar programme. It's maybe quite apt that we're doing this on the anniversary of the first lockdown. And the question that is in all of our minds is, how have we survived? And we have survived, but more to the point, how have our clients survived? And what can they do in this strange time in relation to leasehold liabilities? What can landlords enforce and what can tenants argue? And to that end, we have two excellent speakers for you today. The idea for this seminar is very much born out of the first speaker, Scott Styles' excellent piece in the SLT last year, which was the second in his series on contracts and coronavirus. And it was lockdown and leases and frustration and grounds of illegality in Scotland and England, which piece I would highly commend to you. So on the back of that, I asked Scott to come and speak to us. Scott is a senior lecturer in Aberdeen University and is widely published with an interest in all areas of law, from private law to jurisprudence, commercial law to oil and gas, amongst others. So Scott will be discussing frustration for the first half of the seminar. Our second speaker is Neil Tosh of Axiom Advocates, who many of you will know. Neil called in 2020 and has already built up a formidable reputation in areas including commercial law, professional negligence, insolvency, and of course property. And Neil's going to speak to us in relation to other potential arguments over and above frustrations. We have all the arguments surrounding lockdown and leases, I think, covered. So before we get cracking, a couple of polls for you to start thinking about things. So the first poll, Dawn, if you can get it up, which is, have you been approached by tenants seeking to avoid their liabilities under leases? So hopefully that poll now appears on your screens. Okay, so 83%, 84% have been approached by client tenants in relation to this issue. So it is a live issue which is pertinent to all of us. And of those 84%, I wonder, going to the second poll, do you think it's actually possible for tenants to avoid payment of rent for the period of lockdown? Or are there good arguments that would enable them to avoid that? So that second poll should be there. So we're looking fairly negative. 2/3 of us say no, that there aren't any good arguments. Just over 2/3. Great. Okay, good. Well, we'll see after today. So let's find out, shall we? So Scott's going to speak first, but one final matter is, obviously we're in a Zoom format. So if you have a question that you'd like to pose to either of our speakers, there is a Q&A function on Zoom, which hopefully you have at the bottom of your screens. Please feel free to post any question you like. They will be anonymous unless they're really silly, in which case I might have to name and shame you, but for the most part, we'll keep them anonymous. So please do pose any questions and we'll pick them up at the end. So having introduced everyone, I will pass you over to Mr. Scott Styles. Scott, over to you.
But what I will do is I will send slides to you afterwards. And also, of course, you can always read my articles in SLT. So, as I say in the first of my two articles on frustration, what we really have here is a battle between two very fundamental contract ideas. The first idea, expressed in the maxim pacta sunt servanda, promises must be kept, which is the absolutely central value of contract law, that you're free to make contracts, but having made contracts, you must perform them. When I am allowed to teach my students in the flesh, as opposed to online, I actually get all the students to chant pacta sunt servanda, pacta sunt servanda. And it's a very good way of getting them to remember this important principle. And that's the norm, that's the default setting. Two further things follow from pacta sunt servanda, and these are that you can't change contracts once they've been made. And thirdly, when you interpret a contract, you interpret it in the light of the factors applying at the time of contractual formation. So we don't apply hindsight, we apply what we thought we were contracted to when we made the contract. So that's the norm, that's the 99% default setting of contract law. Well, and one other thing, of course, to mention is contract lawyers aren't, or contract judges aren't much interested in fairness. Another thing I get my students to chant is it fair? We don't care, as you know, their approach to interpreting the case law. So it's very much, you said it, you've agreed to it, you're bound by it. But then we have this exception, frustration. And that's expressed in another Latin maxim, a less familiar one perhaps, non haec infidere veni, from Lord Radcliffe, in UDC. This is not which, that is not which I agreed to. I did not agree to that. I did not contract that. And what the court is trying to capture is this notion that sometimes you build your contract on the foundations of the facts at the time you made the contract, and those foundations have disappeared. So in that context, it's unfair to hold parties to their contract. Now notice several important exceptions are thus arising to our default setting of pacta sunt servanda. Firstly, we're actually saying in this exceptional case, you will not be held to your prior promise. You'll be released from your promise. Secondly, that the courts have a consideration for fairness and justice. And there's plenty of authority where the courts actually say the true rationale for the doctrine of frustration is fairness. It's fundamentally unfair to hold parties to something which was completely unforeseeable. So there's a kind of justice aspect to it. Then the third unusual aspect, contrasting the situation now with the situation at the time the contract was formed. So whilst normally when we interpret a contract, we look solely back in time, we look to the moment at which the contract was formed and all the things surrounding that. And that's true even in this era of the contractual matrix and so on of interpreting contracts. In this, we actually have to compare that situation to the situation now, because the judge has to make a factual assessment as to whether the facts pertaining now are so radically different from the facts obtaining then when the contract was made that you could invoke the doctrine of frustration. And because it's such an exception to the normal rule, the courts have repeatedly stressed the doctrine is not to be invoked lightly. That is, you've got an uphill struggle to persuade a court that a contract has indeed been frustrated. And perhaps more than any other area of the law, one has an uphill struggle to persuade the courts that a contract has been frustrated in the matter of leases. Because by definition, a lease will be a contract for significant duration, or usually for a significant duration. It's a long-term contract in the way, for example, many contracts or services would not be. There might be a one-off or fairly short-term or whatever. So one can see straight away the different dynamics there. And however, and I think this is an area where Scots law differs significantly from English law. In English law, for all practical purposes, it seems to be impossible to escape a lease. The original doctrine was it just wasn't possible at all. This arises out of the English doctrine of an estate and land being a separate thing, abstract thing in its own right, which is unaffected by the realities on the ground, literally, and therefore one cannot escape it. More recently, by more recent, I mean in the last 50 years or so, the courts have, in a couple of judgments, said, well, on rare occasions, we might be willing to allow that a lease can be frustrated. I think it was Lord Hailsham said it was like HMS Pinafore. No, not never, well, hardly ever. So hardly ever would they allow it. But again, we've actually not seen a single case to that effect. In Scotland, by contrast, we do have cases where leases were found to be frustrated. So it's definitely a different kind of dynamic in Scotland to begin with. Now, whether or not the courts would actually apply, I don't know. But that's the sort of situation at the present time. The other aspect I think it's worth mentioning at the moment is the interrelationship with force majeure clauses. Now, frankly, the relationship is not clear. It's not entirely clear for the case law whether the force majeure clause automatically displaces the doctrine of frustration or supplements it. In reality, the way most of the cases have gone is the courts have tended to say if there's a force majeure clause, we'll interpret that, and if it covers the same territory as the event that people are complaining about, the frustrating event, then we'll apply the wording of the force majeure clause rather than the common law of the frustration. Now, I actually think this is a rather perverse way of interpreting the law, and that perversity has reached, in my own opinion, new heights in the fairly recent case of Classic Maritime. And again, I'll send you some slides for that afterwards, but not just now. Where the court held that basically they looked at a force majeure clause and they said, oh, it's not really a force majeure clause, is it? We have to think it's an exemption clause. And if it's an exemption clause, and we have to think of causation, and then we're going to apply the but-for test. What happened was it was a contract could be performed partly because of incompetence by the suppliers, but also because of a volcanic eruption. Now, clearly, a volcanic eruption would be a classic frustrating event. But effectively, the court disregarded the frustrating event, said they would apply merely the force majeure clause, which they read this as an exoneration clause, and said the exoneration clause was subject to a but-for clause. Their argument being, well, even if there hadn't been a volcanic eruption, you wouldn't have been able to deliver because of your own failures and incompetence, therefore you're still liable. Now, with all due respect to the English Court of Appeal, to me, this seems to completely reverse the purpose of force majeure clauses. The reason we have force majeure clauses is precisely because it's difficult to obtain, well, two main reasons. It's difficult to get frustration from the courts, and secondly, the remedy available is a bit brutal. You kill the contract, and then you may or not be able to apply in Scotland for unjust enrichment. A claim, if you're in England, you apply the Frustrated Contracts 1943 Act. But either way, it's a bit rough and ready and not very easy. So traditionally, the reason why people put force majeure clauses into their contracts is to make it easier to cover the same kind of territory as would be covered by frustration. So, it's like belt and braces, if you like. But the way the courts have interpreted, especially this more recent case of Classic Maritime, is actually the reverse, and actually making it harder. And I think, to me, the most damning thing why I think Classic Maritime was wrongly decided was, had there been no force majeure clause present, then the charterer would not have been likely to have escaped liability because we've been able to rely on the common law doctrine of frustration. Practically, I mean, when one looks at if one's drafting a force majeure clause, my advice would be, also what your client wants, is to actually expressly state this does not displace the law of frustration where applicable. So in other words, you can have the belt and braces, which is, I think, what most people want. Of course, I could be wrong. Perhaps parties do want to restrict it as much as possible. But the whole fundamental idea of both frustration and force majeure is that whilst we all totally sign up to strict liability in contract law, pacta sunt servanda, no excuses are permitted, it's not reasonable to compel people to perform in circumstances which they couldn't foresee. And by the way, and I'll just leave you with one last thought on the difference between frustration and a force majeure clauses. The whole essence of a frustration is that, and again, it's set out in my slides in some detail, is that the event be unforeseeable or very unlikely, and beyond the control of the party. So the whole idea is an unexpected event. Whereas with the force majeure clause, to some extent, you have to prophesy, you have to say what could happen. And the difficulty with that is that then you're tied to the wording of the contract in question. And in particular, if you're the client trying to escape the liability, there can be an issue if you have what I call a closed force majeure clause. In other words, a list that says A, B, and C shall be frustrating events or force majeure events, but nothing else will be, full stop. Personally, I think the better style is to give what you think might happen, your prophecies of things that might go wrong, and then add and any other similar events. So anyway, I don't want to go into Neil's time, so I'll stop there. Okay.
Good afternoon, everyone, and thank you, Scott. I don't need to tell this audience that the pandemic has given rise to a whole host of interesting and diverse issues for landlords and tenants to grapple with. For the purposes of today's discussion, I propose to focus on two topics. Firstly, frustration, to pick up the threads of Scott's discussion on that issue, and to look at some recent developments both at home and abroad that might give us some idea of how the courts in this jurisdiction will apply the doctrine of frustration when tenants' businesses have been affected by the pandemic. And then I'll go on to look at the question of suspension or abatement of rent. So the circumstances where, assuming frustration has not operated to bring a lease to an end, tenants might be entitled to some form of reduction in rent. So I'm going to start by looking at the question of frustration in the context of frustration by supervening illegality, and that formed the subject matter of Scott's second article, and I join Gillian in commending both articles to you. There was, towards the end of Scott's second article, there was an interesting conclusion, which it may be that we can discuss later on. But Scott suggests that if a Scots property is let for the express purpose of conducting a prohibited business, such as a pub or cafe, then there's a strong argument that such leases were ended by a frustrating event in the form of the first lockdown regulations when they came into force on the 26th of March last year. And it struck me that if that is so, then it may well bring about quite an undesirable outcome for both landlords and tenants alike. Because it seems to me that having gone through the past 12 months or so, for landlords and tenants to be told that a further consequence of the coronavirus is that the leases they entered into before the pandemic hit have now been brought to an end by operation of law through the doctrine of frustration would be, certainly in some cases, a surprise. Certainly in some cases it will be it might be a welcome surprise, particularly where either landlords or tenants wish to escape a lease or to substantially renegotiate its terms. But it seems to me that in the vast majority of cases, landlords and tenants will probably want to get back to their pre-coronavirus trading positions as quickly as possible. And the idea that in the case of a landlord, they no longer have a sitting tenant, or from the perspective of the tenant, that they no longer have business premises from which to operate would be another unwelcome shock to the system, particularly as hype builds towards the in the lead up to the easing of the lockdown restrictions next month. So I approach the question of whether frustration operates to bring a substantial number of the leases of high street shops and other businesses to an end with some degree of circumspection. But I suppose, moving on to actually dealing with the law, as it were, Scott's article suggests that perhaps one of the easiest grounds in which the courts can consider whether a contract has been frustrated is in the context of supervening illegality, because it is binary on one view. Something that is either illegal or it's not. So if we take, for instance, the classic Scottish case on supervening illegality, James B. Fraser and Co. Against Denny Mott Dixon. And then that involved what was held to be in substance an agreement for the trading in timber. And when the Second World War broke out, emergency legislation was brought in making trade in timber illegal. And that agreement was held to have been brought to an end by frustration. And that makes sense because the very thing that the parties had contracted to do had become illegal. But contrast that with the next decision in London and Northern Estates Company and Scheslinger, where Mr. Scheslinger was Austrian. He had a tenancy of a flat in Westcliff-on-Sea, which is on the banks of the Thames estuary. The lease provided that the flat could only be used as a private dwelling, and that it could not be assigned or sublet without landlord consent, which would not be unreasonably withheld. When war broke out in August 1914, the tenant became, as the textbooks say, an enemy alien. And that meant that under certain wartime regulations, he was prohibited from residing or continuing to reside in certain prohibited areas, which included Westcliff-on-Sea. He defended a claim brought by his landlord for payment of rent from the date that the regulations came into force, and the court found for the landlord. It observed that the regulations did not make it illegal for an enemy alien to hold a lease of land, even within the prohibited areas. It was only the tenant's personal enjoyment of the premises that was prohibited. He could have sought to assign or sublet, or he could have simply allowed one of his friends to stay in the flat. So the landlord's claim for rent was upheld both at first instance and on appeal. And when one comes to consider the various lockdown regulations, one will find that in general terms they require certain businesses to close or to cease to trade for a limited period of time, but they don't render performance of the core obligations of a lease illegal. So they don't prevent leases being granted, and they don't prohibit rent being paid. On the analysis in London and Northern Estates Company, there may be a reasonable, good argument that in most cases leases will not be brought to an end simply by the enactment of the lockdown regulations. Now, Scheslinger was applied by Mr. Justice Marcus Smith when he came to decide whether Brexit had the effect of, amongst other things, frustrating by supervening illegality a lease of the EMA's premises in Canary Wharf. And what he took from Scheslinger was that for supervening illegality to frustrate, it must remove all or substantially all of the benefit that one party receives from the contract. So it seems to me that a much closer analysis of the facts will be required before one can say that a lease has been frustrated. Simply following the enactment of the various lockdown regulations. And to illustrate that point, I propose to look at what I'll call the Caffè Nero cases. Now, the first is a Scottish case, and there's no written decisions, so far as I understand it. The information I have is taken from an account of the case in the Lexology Journal, which was published last month. The facts are these: that Caffè Nero had an outlet in Edinburgh. It was required to suspend sit-in trading between March and July last year, but it could, and indeed did, continue to provide takeaway coffees. Caffè Nero failed to pay its rent due under an extract registered lease. A charge for payment was served, and the case came before Lord Fairley on Caffè Nero's motion for interim interdict to prevent any diligence being carried out on the back of the charge for payment. Caffè Nero argued that the lockdown regulations had caused a total constructive destruction of the premises. However, that argument was rejected, and the motion for interim interdict was refused. The brief account of the case indicates that Lord Fairlie took into account some of the following factors. Firstly, the regulations were in force for a relatively short period of time. They did not prohibit use being made of the premises. Indeed, use had been made of the premises. And the user clause under the lease was also a relevant factor. It permitted the full range of use provided for in Class 1 of the Scottish Use Clauses Order, which covers use for a wide range of retail services. Now, we don't know what authorities were before the court in Caffè Nero, but that decision does seem to me to be consistent with an earlier decision of the First Division in Heartstresses against Arrol from 1903. Their premises were let exclusively for use as licensed premises, but after 3 years of trading, the tenant's licence was not renewed by the licensing authority. The tenant argued that the lease was brought to an end by the loss of the licence and that the consequent failure of the purpose for which the premises had been let. Now, interestingly, in the course of the action, the landlord agreed by minute to remove the use restriction, and that may well have been significant in terms of how it informed the court's decision, because Lord Maclaren said that this was not a case of total or partial destruction of the premises. The premises were as perfect as ever, and all that has happened is that the landlord agreed to dispense with the condition that has now become impossible. And that for me raises two queries. First, whether a court now would give effect to a similar undertaking by a landlord, which may well merely amount to an offer to vary the lease. But secondly, if the landlord in Heartstresses had not offered or agreed to remove the restriction on use of the premises, would the court have reached the same view? And it seems to me that reading elsewhere in the decision that it may well have reached the same view, because Lord Maclaren goes on to say this, and then he quotes from the decision of the Lord Ordinary, who said this: the authorities were against the suggestion, and on principle, I can see no reason why, that apart from express agreement, a failure of the purpose for which a tenant leases a house or shop should, even if the purpose is expressed in the lease, liberate the tenant from his obligations. Now, admittedly, Hearts trustees predated the what are known as the coronation cases, where the concept of frustration of purpose is now attributed. But there is a question mark over the extent to which Scots law recognises failure of purpose as a ground of frustration. Professor Gloag expressed considerable doubts about that, and McBride's view is simply that the answer is not clear. If it does, it may provide a basis on which some leases may be said to have been frustrated, as illustrated by the next Caffè Nero case, which comes to us from the Massachusetts Superior Court. In this case, there was a 15-year lease of retail space that could only be used for a Caffè Nero themed cafe. From March to June 2020, a government order was in force which prohibited the sale of food and drinks on the premises, but it permitted takeaways, and Caffè Nero closed its premises and stopped paying rent when that order came into effect. The court concluded that Caffè Nero's obligation to pay rent was discharged while it was barred from letting customers eat or drink on its premises. During that time, the entire purpose of the lease, which was held to be the use of the space inside the cafe to serve coffee for on-site consumption, was completely frustrated. Now, the position might have been different if the lease had permitted the premises to be used for other purposes not barred by the government order, but its use clause had been narrowly drafted. And so it seems to me that if frustration of purpose forms part of Scots law, and one has a very narrowly drafted permitted use clause, then frustration of purpose may well provide a basis on which a lease may be said to have been frustrated. But if Scots law does not recognise frustration of purpose, then it seems to me that the burden for a tenant or indeed for a landlord who wishes to escape a lease, maybe the higher one of having to show that all or substantially all of the benefit to one party of that lease has been removed. I pause to note simply that these arguments around frustration of purpose and also impossibility as a result of government orders has been the subject of a number of decisions of the courts in New York. These are all cases from the Supreme Court of New York County. There's probably not time to go into the detail of any one of them, but they do, broadly speaking, illustrate the point that these cases will really depend quite firmly on their various facts. And it seems to me as well that there are perhaps different judicial approaches being taken even within that same court in relation to the operation of the doctrines of frustration of purpose and impossibility. And it may well be that we need to wait and see what approach the courts in this jurisdiction will take on similar facts. Moving on then to deal with the question of the suspension or abatement of rent. And I'll start firstly by looking at rent suspension clauses. And there's an example on the screen there of, as will be well known to this audience, commercial leases will often contain provisions which provide for rent to be suspended where premises have been damaged or destroyed, usually or often at least, where the damage or destruction has been caused by certain defined risks which can usually be insured against. Now, I understand that there's presently litigation ongoing in the High Court in England, where it's being argued that in clauses of this nature, then the word damage should be construed so that it's not confined to cases of physical damage, but instead it should also be construed to encompass economic damage brought about by the pandemic. Now, as far as I can tell, there's not been a decision in that case yet, but I do note that there was a similar line of argument pursued in a case in New York, in Dr. Smood New York LLC against Orchard Houston from November last year. And that case involved a 10-year lease of cafe premises, and it included a clause to the effect that if the premises were damaged by fire or other casualty, or if the building was damaged such that the tenant was deprived of reasonable access to the premises, then rent and other charges would be produced in proportion to the area by which the part affected bore to the overall size of the premises. And the tenant argued that there had been property and physical damage caused by COVID-19 and the risk that the virus posed to the public, and that an executive order which had forced the cafe to close between March and July 2020 had rendered the premises inaccessible and unusable, such that a total abatement of rent for that period was due. Justice Love held that the argument was totally without merit because no physical harm had been caused to the premises, and that was an end to that particular argument. Now, it seems to me that arguing that the coronavirus amounts to physical damage to premises failed for fairly obvious reasons. But it does seem to me that the more subtle argument that may be being pursued in the High Court in England, that an appropriate construction to the word damage may include economic damage, may have slightly better prospects of success, but that remains to be seen, and I'm reliably informed that the decision of the High Court is expected relatively soon. But moving away from express clauses, where there is no rent cessation clause, there has been some discussion, at least in England, about the possibility that such a term may be implied, and considerable doubt has been expressed about that. But in Scotland, I think that particular issue may not need to be addressed, because tenants may well be able to fall back on the common law principle of equitable abatement of rent. The leading authority on that principle remains Muir against McIntyres from 1887, where Lord President Ingalls said this: "It is quite settled in law that an abatement is to be allowed if a tenant loses the beneficial enjoyment of any part of the subject let to him, either through the fault of the landlord or through some unforeseen calamity which the tenant was not able to prevent." And more recently, we have had a detailed consideration of the principle in Ferns Trustee 1 Limited against Scott Wilson Railways Limited, which is a decision of Sheriff McCormack at Glasgow Sheriff Court, which was issued at the start of October last year. It arose in circumstances where remedial works were had to be carried out to cladding of a building through no fault of either the landlord or the tenant. It was agreed that the remedial works were substantial and they were scheduled to take I think it was 93 weeks or so, so perhaps just short of 2 years. And the tenant averred that as a consequence of the ongoing works, it was denied access to part or all of the subjects which had been let. And in those circumstances, the sheriff held after debate that in principle, the tenant was entitled to an abatement of rent, and he allowed a proof on the question of the extent of any abatement. And there are a number of points that can be taken from this decision. The first is that whether the tenant has been deprived of beneficial enjoyment will really depend on the particular circumstances. The sheriff offered the example of a meditation centre, which might have been rendered unusable by substantial remedial works of the kind that were contemplated in Fern. But he said that the same works might cause no difficulty at all where the subjects let were an unmanned storage warehouse. So in the case of a pub where the lease provides that it shall only be used as a pub, it may be quite easy to determine whether the tenant has had beneficial enjoyment of the premises. But it may not be so clear where the premises may be used for a wide range of purposes, at least under the lease. But the tenant argues that the specific purpose for which it wished to use the premises was not possible as a result of the lockdown restrictions. The second point is that the sheriff considered what amounts to an unforeseen calamity. And he said this at paragraph 14, that the words unforeseen calamity in context means some unforeseen external reason, not necessarily a force of nature, as might be implied by the words, but not an insured event or a common repair, as such events are provided for or contemplated in terms of the lease. So it would seem, and sorry, we're looking for some extreme unforeseen external reason that necessarily erodes in whole or in part the beneficial enjoyment of the premises by the tenant. So it would seem that, at least in principle, that equitable abatement may well apply in the circumstances which have been brought about by the pandemic, unless there is an express provision covering off the risk of pandemics, disease or such like, for which the parties have agreed that insurance should be taken. The third point is that the principle of equitable abatement can be waived, either expressly or by implication, but the common law rule will prevail unless the lease clearly negates it, and it may well be that it is excluded where there's an express rent suspension clause. So far as I can see from Fern, I don't think there was such a clause there. But the landlord did argue that a number of clauses in the lease had the effect that the tenant should be taken to have impliedly waived the right to an abatement. And those clauses are common, so I'll mention them. The first one was a clause providing for rent to be paid without deduction, retention or set-off. And secondly, a clause that the lease and the obligation to pay rent would continue notwithstanding any damage or destruction to the premises. But the sheriff disagreed with the argument that the tenant had impliedly waived the right to an abatement. And he said this, that the principle of abatement, if established, means that rent is not due or chargeable. It is a common law equitable principle distinct from the parties' rights under the contract. The remedies of retention of rent, set-off or compensation are discrete to abatement. and nowhere had the defender impliedly waived such a right, whether or not by necessary implication. So it's not the case that the tenant must necessarily pay the rent and claim his abatement later, as might be the case where damages are claimed. Now, the last point to be taken from Fairness Trustees is that the extent of any abatement is likely to be highly fact sensitive, and the court is perhaps only likely to deal with that particular matter after proof, where it will need to consider whether, and if so, to what extent and over what period the tenant was denied the beneficial enjoyment of the premises. And that might not be a straightforward exercise in the context of pandemic. The older cases generally arise from damage by fire, and it might be fairly easy to say if you've got a premises with 2 rooms, if one of them is burnt out, then the tenant shouldn't be required to pay any more than half of the rent. But where, for instance, a restaurant has been forced to stop serving customers on its premises, but has been able to continue providing takeaway and delivery services, it may be an altogether more difficult exercise. There's not a huge amount in the way of principle how one goes about assessing the appropriate level of abatement, but the following authorities perhaps offer something. The first is Renfrew District Council against Gray from 1987, a decision of Sheriff Principal Kaplan, and that involved a tenancy of a house which was in an uninhabitable condition, but the tenants did in fact inhabit it. So that makes the first point that continued occupation does not necessarily bar a claim for a rent abatement. The sheriff in that case determined that, the sheriff principal determined that the premises, because they were uninhabitable, no one would let them, and so they had no lettable value. And so that might suggest that one has to look at the lettable value of premises and perhaps compare if a restaurant has only been able to operate as a takeaway, and perhaps we look at what the lettable value of a takeaway might be. But Sheriff Principal Kaplan also noted this, that if it could be shown the tenants had gained a positive benefit from the property, then this could be taken into account in arriving at an abatement. It was simply that in that case, none had been pled by the landlord or established proof. So it would seem that, at least in principle, that one might look at how a tenant's business has performed and whether there are any disadvantages caused by the pandemic were outweighed by any advantages which are offered by the present circumstances. And certainly it seems to me that some businesses, whilst they're on sales, certain restaurant businesses should say, whilst they're on sales, business has, for obvious reasons, dropped to nil. Takeaway business has performed exceptionally well. The last case I'll mention is one which comes from Chicago and in Ray Hilt's restaurant group, and that obviously didn't involve any question of abatement of rent. It involved a question of a lease of a restaurant which had a force majeure clause, providing that the landlord and tenant did not have to perform their obligations under lease where they had been prevented, delayed or hindered from doing so by government action. Now, in March 2020, the sale of food and drinks on the premises was prohibited by executive order, but takeaway and delivery services were permitted and indeed encouraged. And the judge there said that to the extent that the tenant could have continued to perform those services, its obligations to pay rent is not excused by the force majeure clause. The tenant's obligation to pay rent is reduced in proportion to its ability to generate revenue due to the executive order. So that, I think, might be used to support a view that even if a hospitality business could have, but does not, in fact, operate as a takeaway instead of a restaurant, for instance, it will still be treated as though it could have done and assessed on that basis. Now, in this case, neither party offered much assistance to the court about how much of a reduction would be appropriate, but the tenant did suggest that probably around 25% of the restaurant square footage, which included the kitchen, could have been used for a takeaway and delivery services. So the judge made a preliminary determination that the tenant would be liable to pay at least 25% of its outstanding rent, and that percentage was likely to increase as the government restrictions were relaxed. So no doubt there will be different ways in which to approach the question of an appropriate abatement, and that is one amongst a number of interesting issues which will continue, no doubt, that we will continue to have to grapple with over the months and years to come. At that point, I think I will stop and pass back to Gillian for any questions.
That was great. Thank you so much, both Scott and Neil. Plenty of food for thought. We have had a few questions that have come in, which I wonder if you two could apply your minds to. So the first one, an easy one, and you guys may not know the answer, but maybe somebody on the audience does know the answer, and if so, please put in the Q&A function, which is, does anyone know if the firm trustee case has been appealed? Because of course it is just a share of court decision. Does anyone have any insight to that? I don't know. No. No. So apologies, we don't know. If somebody does know, please feed that back to us, but for now, no idea. Okay, and a couple other questions, which I think you've picked up as you got further into your talk, Neil, but just for the sake of completeness. The first relates to the American cases that you referred to, Neil. Are they saying that the leases are frustrated, that is to say the leases are an end, or are they simply saying that the obligation to pay rent is suspended, and if the latter, on what basis is rent suspended in those American cases, by implied term or otherwise?
There's a mix, essentially, depending on what the particular tenants were contending for, but they do seem to recognise adoption of partial frustration. So effectively, only the obligation to rent was to pay rent was suspended for a period of time, which does seem certainly different to our conception.
Mm-hmm.
But beyond that, the cases do seem to me to offer some insight, even if they're only considering the same facts, because the question of whether the purpose of the lease or whatever was frustrated does seem to me to be considered on largely the same grounds as we would if frustration of purpose is a part of Scots law.
And on a related point, and again, I think you covered this off later in your talk, but again, to completeness, for equitable abatement, I can't talk today, does the tenant have to be denied of all beneficial enjoyment? For example, a restaurant running its kitchen to do takeaway, do I understand that the court's jurisdiction take a view as a potential partial reduction in rent, which I think you dealt with?
Yeah, so sorry, to be absolutely clear, the question of the extent of the abatement is one that's for the court to determine, as I say, usually after proof taking into account the whole circumstances. And so it may well be that in some cases it will be a total rent abatement that's due. But I suspect that in many cases, and the example that's given is probably one of them, where there might be some quite difficult exercises to be carried out to work out what an appropriate percentage abatement would be.
I think that's right. And you gave us a number of examples there of how the court might approach that quantification. A related point is obviously a number of these cases deal with restaurants and whether or not they can be used as takeaways, but what about businesses where the purpose of the lease is more or less wholly frustrated? For example, soft plays, they've been completely shut down and there's been quite a lot of noise from the soft play sector during the epidemic, or theatres, where the purpose is completely frustrated, stroke the sole purpose use of the premises and only use for which they can be made has become illegal. Do you think the argument for frustrations may be stronger there? That's to Scott and Neil.
Well, I'll come in. I think the case of theatres would be very clear. They can't use the theatre for the purpose for which it's designed. They have no income. And that frustration of purpose, and of course, as we all know, law frustration began with a case involving burning down of a theatre. So I think there'd be no difficulty with that at all. And if I come back to the beginning of Neil's talk, he said it would be very unwelcome to parties if the contracts were frustrated. Well, obviously, if both parties are happy, nothing will happen. My intuition, could be wrong, is that the tenants are a lot less happy than the landlords. The landlord is getting quite a high rent, with a tenant who has no income. So I see the motivation comes. And as for the being unhappy, well, obviously what would happen in the real world is the disgruntled theatre tenant or pub tenant, if he could get the contract frustrated, he then renegotiate it, but at a new lower rent. That's, I think, what would be the reality of it. And I'll make one last point. Neil made much of Hearts Trustees, very old case, 1903. The cases you're criticising, like Denny Mott, House of Lords, 50 years later, and the whole growth of law frustration was only getting going in 1903, not just the coronation cases, but the cases of the Second World War and the Second. So I don't think, and if I was counsel arguing before my learned friend, Mr. Tosh, I would say, with all due respect, that case is no longer especially relevant. But you can come back to me on that, Neil.
It seems to me that the law is not at a point where it's so sufficiently clear that we can rule out the potential for arguments along those lines to be run. And as I say, McBride, writing in 2006 or 7, still says that significant parts of the law are unclear on these issues.
Oh, absolutely. Well, I agree with that. Yes.
So I am at this stage. I don't think anything is to be ruled out. So I'm conscious of the title of the talk was what's arguable and what's not. In the former category, and
Sure.
I'm not at this stage willing to put very much into the latter category.
Absolutely, yes. I agree. It's all very uncertain. Yeah.
I think a related question that's also come in, we're looking at leases of commercial leases and retail premises. They're closed for a period as a result of CV19 restrictions. Would the panel consider that storage of stock may be a positive benefit for the use of the premises and the extent of any abatement? Are there any other examples, I suppose, again, out with the restaurant and takeaway trade? I suppose it's the same for offices, because most of us have been out of our offices. We can't go in, but they're still used for storage of furniture and whatnot.
I would guess it's all very fact specific, and so we take the example of an office. I don't think you're getting much benefit having an unoccupied chair and desk in your office. On the other hand, you could say if you're storing valuable files, if you've got a computer server or whatever that's actively still productive for the firm, that would be a different matter. So I suspect it'd be very, very fact specific. We take your example of the theatre. Well, most theatres would have some store with costumes and sets and things. But so there might be some benefit, but at the very least, it would be only a minor, improvement, as it were, from the taking away from the major purpose of their business, performing plays or serving beer.
So it's fact specific. Neil, do you agree with that?
Yeah, I totally agree with that. I think there are aspects to some businesses where a presence on the high street will be quite important, even if they're only operating an online store service. The fact that you're actually on the high street, I think, will have some value to it. And there will no doubt be a lot of businesses who, whilst they're not actually trading and opening their doors in the high street, there may be operations behind the scenes where having a physical presence is important. And I've certainly not seen, and others may have other experiences, but I've certainly not seen a lot of people trying to get out of leases. And I think that, or permanently, and giving up their presence. And as we approach the end of this lockdown period, I think there's a real advantage to a lot of these businesses to be able to turn the tap back on immediately. So I think that's one of the major disadvantages of some kind of frustration analysis, is that if people wanted to start trading again, they would have to totally renegotiate at least terms, etc. Whereas, as matters stand, they can. And I've seen some restaurants doing it. They're doing pop-up days where they just open for one day and then close. As we come, I think it's the 26th of April, they will all be, if touch wood, we'll all be back to opening it, not quite as normal, but much closer to that. So there's an advantage to that as well.
Do you think it's maybe not enough to find frustration, but do you think there's enough in there to find abatement of rent following Friends Trustees? would storage of stock or the use of desks and whatnot, sort of back office operations, be enough sufficient beneficial occupation, or do you think abatement might still be arguable in those circumstances?
I think abatement would absolutely be arguable, and because in the cases where there has been a total abatement, as I say, most of the older cases deal with fire, so they're literally uninhabitable premises. But where premises are, at least in theory, inhabitable, and where, as you say, there's items stored there, there's a present, there must be some value to that. And so I suspect that an argument that there should be a total abatement in many cases may not succeed. I think there's, but as I say, it seems to me it's quite early days to reach any firm views on that.
And of course, I think that probably begs the question of, you touched on withholding rent and how abatement interplayed with withholding rent, but there'll be a number of tenants who've probably been paying full rent throughout the period without abatement. Do we think that there's a recourse then against the landlord in relation to an overpayment of rent, if that's what it is, or do we think it has to be withheld at source?
There would be a claim for unjustified enrichment if rent had been paid in error, and indeed I think there was a claim in unjustified enrichment in Fern. So yes, but what the cases tell us is that an abatement is not in the nature of compensation or damages. It is it's a question of whether the rent is due in the first place.
Absolutely, yeah.
Globe speaks about a tenant essentially being able to withhold payment of rent until the amount of any abatement is fixed. So for those tenants who have not been paying rent without having necessarily agreed that with their landlords, then the question of equitable abatement and that right of retention may well be something that they can rely upon to resist any action that's taken to bring that lease to an end by means other than frustration.
Sure, absolutely. Yeah, I entirely agree with Neil. I mean, the whole logic of abatement is that the claim was abated, that it just didn't fall due at that time. So if you've paid in any case, then clearly you're entitled to have it back. So I think but as ever, you both agree, everything's going to turn on the facts, So I think these will be very fact-specific cases, and it'll be quite. So every case will be up for grabs in a sense if you're pleading it, because no two cases are alike,
And that's what we love as litigators. That's what keeps us busy. Well, I think that's us gone through all the questions. If you have any question, now's the time to type very, very quickly, and we'll get that to our panel. But it's so interesting to see these really old principles, some of which many of us may never have heard of before, for trustees, coming to play in modern times and providing sometimes some problems, sometimes solutions. So it's a really fascinating time for contract law, I'm sure we'll all agree. So with that, I think we can round up today's seminar. Thank you so much for joining, and thank you so much to our panelists, Scott Stiles and Neil Tosh, for such an insightful and, I'd like to say modern, but certainly interesting, but old-fashioned and American talk. It's great to see what's happening in our jurisdictions. So thank you very much, everyone, for joining. And just a reminder, the next in our series of seminars will be the Property Standardisation Group coming to talk to us about their approach to the PSG standard leases, and that will be on the 18th of May. Details will be very shortly on the PLA website, so please come along to that. Rich Feeling, thank you very much for joining, everyone, and hopefully see you all soon. Take care until then. Thank you.
Okay, bye. Thank you.